for those that don't know me, my name's Kyle Medeiros, and I'm an occupational therapist at Life Beyond Barriers Rehab Group, and then also the vice president of the Brain Injury Network of Northern Michigan. So Roxanne could not be on tonight. She's going through a little wisdom teeth fun with her son tonight. So I'm going to take care of the intro here and hand it over to Sandy in a second and then let the presentation start. But before, just a few announcements. So just a reminder, it seems like everybody's pretty good about getting on and muting their volume before the presentation starts, but just a reminder for that. Also, reminder, it is July, so as Steve sent out, membership renewal or dues are due this month or as soon as possible. If you have any questions, let one of us on the board know about that. If anybody did catch the survey that was sent out by Jenna on MailChimp, if anybody did reply to that survey, we thank you guys for your participation. And if you could please do us a favor and send an email response back to Jenna that says completed survey in the subject line with your name and the best method of contacting, that would be great, because we had a little glitch with MailChimp and didn't realize that we had to put in an area in there where we needed to ask for name information. So we'd like to, we're going to go based on the honor system here so that we can try to get that person a free membership for a year. So if you could just send your name and preferred contact information to Jenna, that would be great. And just a reminder too that we did just upload the new grant process that the network has come up with onto the website. So please go on there, learn a little bit more about this grant that's available for a lot of the clients that we service, and please utilize that, those monies and those funds, because we're going to set aside some money every single year to be able to use to help out anybody who's in need, and that's all pending board approval. So check out that process, share it with coworkers. We do ask that you're a member if you're going to utilize those funds, so or funds for a client. So just something to be aware of as a resource out there. And just a heads up too that based on the result of our survey, most people were in favor of a potential fall networking event. So we are going to start working out the details of that. We just want to wait for the next couple of weeks and see how everything pans out here in Michigan. But be on the lookout for some more information on that, and hopefully we can do that in person here in the fall. And lastly, just at the conclusion of the presentation, we'll just automatically sign off here. So just watch your emails for any information and updates on the board or from the board. And if anyone has any questions or ideas, as always, please feel free to get a hold of one of us. Let us know. Keep spreading the word about the network so that we can continue to grow our membership base here. And a little bit of a weird year, but we're gonna just keep going off of it and hope for the best in the months to come. And at that note, I'm gonna hand it off to Sandy here.
Kyle?
Oh yes, Steve.
If anybody needs CBIS points,
Yeah.
they are available on the website. You fill out the form, send them to me, and I'll send you a certificate.
Perfect. Cool. Thanks, Steve.
And before we get started with the presentation, I just want to ask that people mute their microphones during the presentation, but I put up the group chat. So if you have questions that come up during the presentation, we can field those questions to our presenters. Tonight, we are thankful to have two presenters from Sinas law firm to talk with us about the new auto no-fault change and the, and also to talk about the utilization review piece, which we haven't heard a lot about yet because that's still being developed. So our first speaker is going to be Steve Sinas, who I think we all know, so he really doesn't need an introduction, but he's a member of the firm that his grandfather started in 1951. And our second speaker will be Catherine Tucker, and she is the firm's no-fault medical provider practice group leader. and she's the one that does a lot of work in getting providers reimbursed. So without further ado, we welcome Steve and Katie. Thank you so much for presenting to us tonight.
Thank you for having us. All right, yeah, I see familiar faces. Maybe not everybody, but I'm sure many of us have met before, and I know many of us have met before. So it's a pleasure to be with you tonight, even though we're not actually together, but I like to think we are. And I'm very happy to have Katie Tucker here. Yes, her name is Catherine, but many know her as Katie. She is going to do the second half of the presentation tonight. I'll just basically get into it with some introductory comments about how we're going to go about things. My part of the presentation is intended to give you an accurate understanding of how the no-fault system operates now under these reforms. We lived in a limbo year for the last year when they passed the reforms in June of 2019 up until now, where now the new options are allowed to be sold, and many other aspects of the reforms have effectively come into play because of the fact that all the options are out there. So with that being said, I'm going to share my screen, and I'll just, well, actually, before I share my screen, let me just say this. I'm trying to give you an overview of what the law is, and at times I'll explain what the law was, but I just think we all need to have a good understanding of how this system works, and yet understand how it's still based on the old system, but just different in very significant ways. So with that being said, I'm going to go ahead and share my screen. Can people see my screen now?
Yep.
Yes.
Okay.
Yeah.
All right. So in order to understand the system as it stands now, I'm going to have to cover a little history, because I think you need to understand some terminology and what these systems once were in order to understand what the system is now. And before the no-fault law was enacted, Michigan had a tort law system that governed how auto accident claims were handled. In 1973 is when we enacted the no-fault law. You might say, well, wait a minute, what's tort law? Here's the general concept. An injured person can recover their economic and non-economic damages from the at-fault driver. In other words, all their damages from the at-fault driver. And if you are the at-fault driver and you can't blame anyone else, or there's no one else to blame, such as black ice accidents, deers jumping out at you, whatever it may be, single vehicle accidents, there was no real right to recovery. So tort law is this fault-based approach where you get all damages from the at-fault party and no damages if you are the at-fault party.
What's that?
And in reality, tort law has its limitations in the.
I think it's mute.
Someone's not muted, but in any event,
Right
the realities of tort law, even though the system doesn't really limit the damages that you can recover from the at-fault party in the sense that you can get a jury verdict for whatever amount of jury awards, there are insurance policy limits. So I'll talk about that as we move along here. And with this slide, this summarizes why Michigan got away from the tort system and enacted the no-fault system. And it was that the medical expense coverage depended upon findings of fault. It was litigious because of that. It was inefficient because of the litigious side of it, and because people had to argue over fault and gather evidence, whatever it may be. Even if you weren't in litigation, it was hard to tell who was going to be determined to be the at-fault party, whatever it may be. There was inefficiencies as part of the system from the get-go, following many crashes. And in the end, the auto claims and the healthcare economy they were not functioning the way that the healthcare economy needed it to, because of the fact that the bills were not paid and the system didn't have full compensation for injured people. So the healthcare economy was hurting under a tort-based system, with auto accidents being such a contributor to healthcare needs in our state. So the grand compromise of no fault, as we all, I think, know this story, but just to remind you, is that we're going to have this system where, as long as you're in an accident, you were able to have full coverage for your injuries. And this system was a novel system at the time it was enacted in Michigan in 1973. But the whole idea was that we were no longer going to have to chase at-fault drivers for full coverage of people's medical needs. People were going to insure their vehicles with no-fault insurance, and that system would develop into a system where, as long as you weren't disqualified from benefits for certain limited reasons, everybody would have lifetime coverage. For that reason, the tort claims didn't need to include medical expenses, and in fact, they couldn't under the original no-fault law. Here's an overview of the reforms in terms of what it did do and didn't do to the original no-fault law. The reforms did not repeal the original no-fault law. We still have the Michigan no-fault law. The reforms greatly modified that law, however. And as I'm going to try to explain here, hopefully succinctly, certain rights and benefits under the law are the same, while there are certain rights and benefits that are vastly different. I think it's important to understand, when you're talking about the no-fault system as we know it now, it still has all the benefits that the old no-fault system had. And that is these 4 benefits I have summarized in this slide. I'm going to quickly just summarize them just to give you a reminder. You have the allowable expense benefit, which is the medical care benefit that makes Michigan no fault really what we know it to be, which is this comprehensive care system. That benefit still exists. However, there are going to be caps with regard to many people's coverages, which I'll explain more as we move along here. There's the work loss benefit, and that benefit is loss of income from work a person would have performed. It's up to 3 years. So if you're in an accident, even if it's your fault, you have this work loss benefit. That benefit is not changed at all by these reforms. So anybody who's a claimant in the no-fault system still has a work loss benefit. The same thing goes for replacement service benefits. This is a limited household service benefit that's capped at $20 a day, payable for 3 years, and it covers ordinary and necessary services, household chores, household maintenance, taking care of your kids, taking care of your pets, anything that can fit under the category of ordinary and necessary services. That's a replacement service. That benefit remains intact following the reforms. Like I alluded to, the reforms with regard to changing any of these benefits really only changes the amount of coverage available under the allowable expense benefits. The other 3 reforms are, the other 3 benefits are unaffected by the reforms. But I will say, and it looks like, I'm sorry, I thought this was going to be part of this slide here. I made this last minute change. The other thing about the allowable expense benefit, though, under the reforms is that there's this new area of regulation known as utilization review. And Katie is going to cover that in part 2. So while I'm saying the allowable expense benefit has not been changed, you're going to see that there are now these new regulations that affect how you ultimately pursue the allowable expense benefit. Just so we're clear, I already said that these benefits are payable as a result of an accident, and this standard is a broad standard where if a person is injured anywhere around a motor vehicle, as long as the motor vehicle is being used for its transportational purpose, you can get no-fault benefits. So there's all kinds of ways in which no-fault benefits are triggered, and these benefits are available to anybody who's injured in an accident as long as you are not disqualified. And real quick, disqualification are those who intend their own injuries, owners of uninsured vehicles, those who knowingly use a stolen vehicle. And then now They're the only exception to the general idea that these entitlement standards haven't been changed by the reforms is that the reform said that all out-of-state residents are disqualified from no-fault benefits. So if you are not a resident in Michigan and you're injured in a crash, you're not going to get no-fault benefits. And the only exception to that rule is if you happen to own a vehicle that's insured under a Michigan insurance policy and registered here in the state of Michigan. So if you think about that category of people, you're going to realize it's a pretty small category of people. And effectively, that means anybody who's not living in the state of Michigan is never going to be entitled to any no-fault benefits. So that is the one new area of disqualification under the reforms. All other people are going to be entitled to benefits. It's just going to be a question of whether they're limited with their medical coverage. Just this is where I'm sorry. I knew I added this thing about utilization review. It was in this slide here. But the point of this slide is to make this point that the allowable expense benefit, which is defined in this section of the No Fault Act, is defined as any product, service, or accommodation reasonably necessary for an injured person's care, recovery, or rehabilitation. The reforms did not change that sentence. That sentence remains the sentence that defines allowable expense benefits. Again, there are caps, and then there's utilization review, but the benefit remains intact as we knew it. To hammer that home, here are some examples of all the ways in which the courts have interpreted that language to result in a payable benefit. Hospitalizations, surgeries, inpatient care, obviously, but nursing and attendant care, at-home attendant care, rehabilitative therapies, medical transportation, medical mileage. I think many of us on the call here know that these are all examples of no-fault benefits, but I guess the real point now is that language that was the predicate to these being determined to be payable no-fault benefits remains part of the law. The question is whether utilization review is going to effectively change that somehow. And that's why we're going to focus so much on that tonight. Coordination. Anybody who deals with the no-fault system must know what coordination means. And this is a concept where if you are insured under a coordinated no-fault policy, that means you have an obligation to go to your health insurance first and pursue all coverage available from your health insurance before you turn to no-fault. This has always been part of the system. It's always been the case that you can't coordinate with regard to Medicaid and Medicare. Actually, there's a couple years where you could. That's not true back in the 70s, but effectively, since 1980, there's been no coordination with Medicare or Medicaid. So anybody who has those forms of insurance couldn't buy a coordinated no-fault policy. You were supposed to get a premium break by elevating health insurance to pay above auto. The question for consumers that was never answered was whether the last 40 years they ever got that break. There's an indication that maybe they didn't get the kind of break they should have, but I guess the legislators this time around didn't want to consider those types of issues and just wanted to limit the benefits available to people going forward. But in any event, just understand that coordination has always existed and it still exists. So when I get into the insurance buying options, I just want you to know that we have to factor in the fact that there could be coordinated PIP choice policies. So I'm just kind of planting a seed to come back to when we're talking about what these options are really all about and what coverage may or may not be there. The other thing about the reforms is that they didn't change the general rule regarding what insurance company you turn to first or try to turn to first to get your no-fault benefits. And the answer to that question is you're supposed to turn to your own insurance company. And by your own insurance company, I mean one that would cover you, or if you didn't have your own, any resident relatives or spouse that may have a auto insurance policy. So you turn to household policies first before you go to any other policy. That remains the rule. There were exceptions to that rule, however, under the original law. And here are a couple key exceptions. Motorcyclists would not go to their own policy. They would go to the vehicle that was involved. You only get no-fault benefits if you're injured on a motorcycle and there's the involvement of another motor vehicle. But if there is, say I'm on a motorcycle and someone were to hit me with their car, I would claim benefits from their policy, not my own. And there's also the same type of situation if you're in an employer-owned vehicle. Say I'm driving my own, or I'm sorry, in a vehicle owned by my employer, and I'm injured. I would not turn to my own personal policy. I would turn to the employer's policy, even if I'm not on the job. So those rules actually remain in effect under the new law. And I'm going to come back to that as we move through this content, because there are a couple inequities that are now going to arise due to these exceptions. But the point here is that this general rule and these exceptions were not changed by the reforms. They remain part of the law. But what the law did do is it changed the second tier order of priority, where you drop down to if you don't have a policy in the household. So say I'm injured and I don't have my own policy. I don't live with anyone else who has a policy. There's no policy in the home. The law took out the right to turn to policies of the other motor vehicles involved in that crash. It used to be the case that you'd work through various ways in which you would claim benefits from other people's policies. The law effectively took that out. And if you don't have your own policy, you now, for the most part, with some exceptions, have to pursue benefits from the assigned claims plan, which is this entity that you make an application to, you explain you don't have your own insurance, and then they take in the claim and randomly assign it to a given insurance company. And it's this bureaucratic process you have to go through and comply with their investigation. And you get in there and you get your claim assigned. And under the old law, going to the ACP might have been a headache, but you were at least going to get the lifetime coverage. Here's the kicker under the new law. You're capped at $250,000 if you end up at the ACP. So the reality here is you still have the general rule. If you have the policy in the household, you're going to get your benefits pursuant to that policy, whatever limitations may have in it. But if there's not, then you're accepted for a few limited circumstances. You're going to end up at the assigned claims plan, and your medical is going to be capped at $250,000. So the other takeaway about this reality is that when you're trying to assess how many people in Michigan are going to have lifetime no-fault coverage, the answer is only those people, again, with very limited exceptions, only those people who are in a household that made the decision to buy lifetime coverage, only those people are going to have lifetime coverage. You're no longer going to have people getting lifetime coverage when they didn't buy their own policy or whatever it may be. You're not going to have that type of situation. It's either you get it if you bought it. And that's a key feature of the reality going forward. Now, the thing about that exception that I was talking about for motorcyclists and also for the employer-owned vehicle is that even though this law was passed on the idea that people should be able to choose their own destiny, those people under these exceptions can't. If I'm on a motorcycle and I chose lifetime and I'm hit by a policy with a very limited medical expense coverage cap on it, I can't access my lifetime coverage because they didn't think through it enough to go in and do the surgery, so to speak, that was needed within the statute to take away that unfairness to me as the motorcyclist who had lifetime coverage on my auto policy. So motorcyclists are, I would use the phrase, playing Russian roulette out there. They could, I guess they also could be hit by a vehicle that has lifetime coverage, and if they didn't buy into it, they could get lifetime. But it's that random. It's so random now under the new law. And I think something that's maybe even more unfair in the sense that when people are driving their employer-owned vehicles, they would like to think that, you know, that they're not sacrificing whatever they may have already bought themselves. But if the employer chooses to cap no-fault coverage, and say I take my employer-provided vehicle, home for the night and I put my family in it and we're going to the restaurant and we're in a crash, we all claim benefits from the insurer, from the employer. And if the employer cap coverage and we have lifetime coverage, we're going to be subject to the cap. So there's all kinds of ways in which this new system creates headaches for businesses, which I find to be somewhat ironic in the sense that they're passing in the name of saving people money and helping the economy. But, you know, at the end of the day, there are a whole bunch of twists and turns within the law that greatly affect the insurance buying decisions of everybody, but I think especially businesses too. So the bottom line for buying no fault going forward is you should do what maybe you've always known that you need, which is you need the lifetime coverage. And I think people on this call maybe have been educated enough that they knew the benefits of the system. And going forward, you don't have to really learn too much about the other options and just know that they're not the right options. The right option is the one that actually covers your needs. I don't like the term unlimited, but it's in the slides here, and it's so baked into the cake now. There's actually, I think in the statute, there's the term unlimited, and so they've used it. But to me, it misses the point because all it is that you get what you need. It's they get you what you need coverage. The other stuff is you get what you need until a certain amount of money and there's nothing more left, even though you might still need it. So I sometimes like to refer to the unlimited coverage as the you get what you need coverage. In any event, that's what you should buy. And it should be uncoordinated for the reason that you don't want to serve the two masters and you don't get the big premium break that you should. So you should go uncoordinated. Now, with regard to the claim against the at-fault driver, under the original no-fault law, as I already alluded to, you couldn't sue the at-fault driver for medical expenses because you were able to get your medical expenses covered through no-fault insurance. So you couldn't include that in the claim against the at-fault driver, which in a way is also a protection for all of us in the event that we make a mistake on the roadway, hurt somebody, and they need millions of dollars of medical care. We know they're going to get it, but they can't sue us for it, meaning you don't have to buy the kind of coverage that would take to cover that kind of loss or worry about your assets being seized because you made a mistake and ruined someone's life. We all had that protection. But if we did make a mistake, we could be sued for non-economic damages, which when I used that phrase before, I meant to define it. This is the pain and suffering claim, the loss of quality of life, the kind of compensation you're giving somebody just because their life has been so horribly harmed by their injuries. So you have non-economic loss. It's always been part of the at-fault driver claim. And if you have wage loss beyond the limitations for work loss benefits, you can sue for that excess economic loss. That was always part of the system. But now, because people can buy limited no-fault policies, which I'm going to give you more of an overview of as I move through the material here, but there suffices to say that people can basically opt out of no-fault. They can buy $50,000 of coverage, $250,000. There's all these limitations now that people can select. And if you happen to be in a crash with one of those people, they can sue you for their uncovered medical expenses. So there is an increased liability in the form of a potential reality where you are sued for a person's lifelong medical care. And that was not something that you were subjected to under the old law. To further understand the right to sue somebody for uncovered medical, you should understand that this right is based on a legal principle known as pure comparative negligence, which means that if you can show someone was any amount at fault, 1%, 2%, 5%, 10%, just any amount, you can pursue your damages against that person for that percentage. So I have an example here on this slide. Bob is 90% at fault. Wanda is determined to be 10% at fault. Bob can sue Wanda for 10% of his lifetime uncovered medical expenses. So if, say Bob was able to show that he has $5 million of uncovered medical expenses, he could still sue Wanda for $500,000 under this principle. And that's now what's part of this system. And I'm not trying to say this because I'm a lawyer and I do handle personal injury cases. I'm saying it because I now see in the system that the tort aspect of someone's legal rights is essential to look into if you're trying to figure out what the medical resources are of people going forward, because they've now made this hybrid system where there is some no fault coverage for everyone, limited for a lot of people, and now people can sue each other for medical expenses. That kind of system means that if someone's injured, they got to track their no fault claim and they have to do a full analysis on their liability claim to figure out what their real rights are. So the liability aspect of these reforms opens us up to more financial exposure if we hurt somebody. And if we're injured, it's something that now we have to pursue or at least examine if we're trying to figure out what all our resources are. The bottom line is that people need to buy more liability insurance coverage because of these realities. So the other thing about this is that under the law, if somebody's in the scope of their employment and they hurt somebody, the business can be sued for the same damages. So if an employee is out there and they hit somebody who doesn't have no fault coverage, has opted out, or only has $50,000 and they need millions of dollars of medical care, the person can be sued and the business can be sued. So businesses will need to buy more liability insurance. I'm going to try to summarize a couple other aspects of these reforms here, just to try to keep things straight about how everything's coming together under these reforms. This first part that I've gone through is supposed to give you an overview of how the benefits still work under the system, how the rules are, and just kind of the new realities on the no fault side and the tort side. I'm going to quickly cover some other aspects here of the reforms that really deserve their own hour, so to speak, or their own focused discussion, which we don't have time here for tonight. But there is a fee schedule side of these reforms that I'm sure many of you have heard about, and there's a lot to talk about in terms of how to deal with the fee schedule. And it's a very complicated structure that they've set up here in terms of determining where your services fall under the fee schedule and how it's supposed to be calculated. But right now, my point is that the reform certainly set forth a fee schedule that you need to understand. The fee schedule is not in effect until July 2021. So you do not need to worry about the fee schedule right now, but you need to start learning about it so you know how to deal with it when it becomes part of the system next year. There are also limitations on family provided attendant care, which basically says that if you know the person somehow because they're your relative, they live with you, or you somehow were friends with them, or even had a business relationship with them, any of these people are limited to being paid 56 hours a week cumulatively. If you have 3 or 4 of these people providing care, it's a total of 56 hours a week that the insurance company has to pay for care provided by people that fall into that category I just summarized. That's a limitation that is going into effect, again, at the same time of the fee schedule, July 2021. The utilization review rules that Katie's going to summarize, that is going to be effective very soon. And we don't know exactly when, but within the next month or two, I think is fair to say. There's also a fraud authority, which is now a part of the criminal justice department through the Attorney General's office. And it's a authority that is created to look into consumer fraud more than anything else. It's not really policing any of the bad acts on the insurer side. It's out to nail any consumer insurance fraud, both on the claimant side or the individual side, the medical provider side, and the attorney side. So there's a great amount of power now to investigate issues like insurance fraud through this fraud authority, and it's out there, and people should just be aware of it. The other thing about these changes I summarized with regard to the fee schedule, utilization review, or that Katie's going to get more into that one, but with regard to attendant care, these are new features and rules of the system, but they're intended to apply to people already in the system. And we, at our firm, actually have a lawsuit pending in the Ingham County Circuit Court about whether that's constitutional. There are other arguments in the case about whether the law itself is constitutional, but the retroactivity of the rules applying to people already in the system is definitely a big issue in that case. And I guess I'll just also mention that the oral argument in that case is scheduled for July 22nd here in the Ingham County Circuit Court, and it'll be interesting to see how that goes down. We can talk more about that in the question and answer session. So by going through all that, it allows me to quickly cover the options that are out there. And so here we go. And I want to take some time to answer any questions about my part before I turn it over to Katie. So I'm just going to go through this and then take some time for some questions for a few minutes. And then we're actually going to take a 5-minute break before Katie starts. So just wanted to give you a heads up on that. All right. Here is a list of the various types of options that are now available as of July 2nd, 2020. You can buy a no-fault policy that has a $50,000 medical expense cap, $250,000. I'm going to give you some more of the details on these, but just understand this is an overview. $250,000, $500,000, lifetime uncapped or unlimited, whatever you want to call it, but no monetary limit. That option is still available. And then there are these ways certain people can opt out. You also could be, you could have available to you the purchase of an attendant care rider, which I'll explain in a second. There's also managed care. And then there's this reality that at-fault drivers can be held liable for an injured person's uncovered medical expenses. That's just kind of an overview. And now I'm going to go into each one a little bit more. Excuse me for a second here. Okay, so with regard to some basic rules about these caps. Sorry. Can you see my screen?
Yep.
No, okay. You can? Okay.
Oh, yeah.
Yeah, okay. Excuse me for a second. Okay. Those monetary amounts only apply to allowable expense benefits. They don't apply to the other what are known as no-fault PIP benefits. They don't apply to work loss benefits. They don't apply to survivor's loss benefits. And they don't apply to replacement service benefits. So the cap is only with regard to the medical expense coverage a person has. The cap applies per individual. So if a family of 4 is insured under a $250,000 policy, they each have $250,000 of coverage for their injuries. If a household has 2 different levels of coverage, say mom has the 250 and dad has the 500, the kid is injured, the kid's going to get 500, not going to get 750. You don't stack the two. There's a form requirement that everyone has to now go through, and CPAN, and we could email you the form, but CPAN has a lot of resources about the insurance buying process now. But if you just go on the Department of Insurance and Financial Services site, or even just your own insurance agent, you're going to be presented with a very complicated form that summarizes all these options. The other thing about these cap policies, they're sold on the notion that they're going to bring down the cost of people's insurance. And you all just should know, as a matter of fact, and just if you're going to be an advocate out there, or just being an informed consumer, that this law does not guarantee that the cost of anyone's insurance is going to go down overall. It's only a reduction on the no-fault portion of your policy, and exactly how that's calculated is pretty ambiguous. It is not an average percentage. I'm sorry, it's not a percentage of the amount the person was paying before the reforms. It's a percentage of the average the insurer was charging across the entire state that becomes the actual guarantee reduction that people should get. And so, you know, exactly what the calculation is going to be is going to be an interesting thing in terms of how that develops. But the law itself does not give the kind of break that people think they're going to get, especially if they were being charged the highest amounts in the state, such as like in areas of Detroit and Flint and things like that. So I think there's going to be some disappointment, and that's not going to be an even trade, given that people that buy these cap policies are going to get so much less. This is an example of what I'm talking about. This is a deck sheet. If you just look at the part that says personal injury protection, this is a policy here in Ingham County that was sold just like 2 years ago. And this is for 6 months of coverage. But the reduction is only with respect to the personal injury protection coverage on the deck sheet. All this other stuff, it does not have to go down. And actually, the amount paid for liability insurance is expected to go up. So one thing about coordination, I mentioned before that I was going to bring this up when we went through the options. It appears to be the case that because coordination is still allowed under the laws, that I can say at this point, many insurers appear to be offering coordinated PIP choice. And if you step back and think about it, it's a big difference saying someone's got an uncoordinated $250,000 no-fault plan or a coordinated $250,000 no-fault plan. And for those who have health insurance and they still want to participate in the no-fault system, they don't opt out, which I'll cover in a second. Those people, if they buy coordinated, are setting themselves up for a situation where they'll have their health insurance there to pay the frontline cost of their medical care, but they'll still have the $250,000 pool of money to cover what health insurance doesn't cover. If you buy uncoordinated no fault, you're essentially just paying more uncoordinated PIP choice. You're essentially just elevating your no fault carrier to pay for your front line of medical care that your health insurance would already cover. So I guess it comes together like this. Everybody should buy lifetime, but if for some reason someone's buying a cap policy and they have health insurance that would cover auto, I think they're much better off buying a coordinated PIP choice policy rather than an uncoordinated one. It just goes to show how confusing these decisions are going to be for people. And you can guarantee that people aren't going to make the right choice they really should have made because they're not going to be informed enough to do it. But hopefully we can all work together to spread the word. With regard to that $50,000 plan, that is only available if you have Medicaid and everyone else in the household has some type of coverage that would cover their injuries if they're injured in an auto accident or on Medicaid. So if I'm on Medicaid and the rest of my family's on Medicaid, we can buy this. If I'm on Medicaid and they're not on Medicaid, I have to show that they have coverage that would cover them if they're in an auto accident. And if I can't show that, then I guess I can't buy this option. So there are some limitations to who can buy 50. 250, there are no limitations. I'm sorry, I think I skipped past 500 here. Okay, at 500, there are no limitations either. Lifetime, there are no limitations. This rider of attendant care that I referred to, apparently the way this works is that for those who buy a limited no fault policy or who opt out, can be presented with this rider that's this additional pool of money to cover their family provided attendant care needs. And it's just like, it's just supposed to be its own unique set of funds to cover that. And the way I interpret it, and I've talked to other agents about this, is that you would buy your PIP choice plan, or if you opt out, whatever may be the reality, and your medical expenses is your reality there. And if you buy this rider, you can go ahead and submit a claim for attendant care, and exactly how much coverage they're going to sell in these riders. I've heard that is up in the air, and that really companies may sell a lot of it. They may sell just a limited amount. This is a new area. The one thing to note about it is that these policies or these riders are not supposed to expand the limitations on family provided attendant care. They're just supposed to provide a pool of money that would be there if the other no fault coverage was used up or wasn't there because the person opted out. So this is another part of the menu. So I've been referring to the opt-outers, and this is a big deal about the system. And what I've said all along is that while the politicians who were talking about the reforms and saying what they would accept and wouldn't accept, some of them said that with regard to PIP choice, they would accept it as long as there wasn't a zero option. And at first blush, it may seem like there's not a zero option on the menu, but there really is, and it's in the form of these opt-outs. And so the first opt-out is an opt-out that is available to people who have health insurance that does not have an auto exclusion. And if they have that type of health insurance, they can completely opt out of medical expense coverage altogether. So a lot of health insurance plans don't have auto exclusions. Your typical Blue Cross plan doesn't have an auto exclusion. All those families can go in now and buying auto insurance and just say, I don't want to have any no-fault coverage. I'll rely on health insurance. I'm very concerned about this because, if you talk to, I should use the past tense. If you talked to any of the legislators who supported these reforms, they acted as if America's health insurance system was always this guaranteed system that was always going to cover people, and there weren't issues about people losing their jobs and losing their health care coverage, and that everything was fine. And we just had this duplicative coverage problem with the no-fault insurance system that just must be eliminated and everybody will be better off. I don't think that's going to be the case at all. I think the opt-outers are in for a really harsh reality where if they're seriously injured and they can't go back to work after a few months, they lose their health insurance, they're going to be between a rock and a hard place for sure, because they're not going to have Medicaid coverage, probably because their assets are going to be too high. They lose their health insurance. They're not employed anymore. And they either have to COBRA or buy their own policy. Not to mention that they don't have the coverage for the co-pays and all the other extraneous medical expenses that no fault typically covers for people that aren't really covered by health insurance. So I think this is a terrible part of the law, and it's a big deal. There's also the Medicare opt-out. This slide right here is just supposed to cover what, it's supposed to illustrate what no fault covers that Medicare does not. And I'm sorry, I meant to have one other slide right before this one. But it's a similar concept where if someone's on Medicare and they can show that anyone in their house is also on Medicare or has health insurance coverage that would cover auto accidents, they can opt out. So for seniors, basically their relief is either to buy a PIP choice policy that's just going to elevate no fault to pay probably what Medicare would pay, or just opt out. And groups that I was advocating alongside with, we're talking about a more unique relief for citizens where they could get the benefit of what Medicare covers, but allow them to still have coverage under no fault for what Medicare doesn't cover. And that's not a possible reality now for seniors. They're either paying what they paid for uncoordinated lifetime coverage, or they're opting out. There's no in between. So I do fear that a lot of seniors are going to opt out. I've helped and represented a lot of seniors in my career, and I've seen all kinds of great things that the no-fault system does for them if they're tragically injured. So I can see how this is going to pan out for people who need long-term care and realize that Medicare doesn't cover. Then they turn to their own assets, I guess, or family. The other, I think, underrated bad aspect of these reforms is managed care. And managed care is the concept that the insurers can write policies that have a bunch of rules about the monitoring and adjudication of an injured person's care, and perhaps more importantly, that they can go ahead and determine what doctors people can treat with. And any insurer anywhere in the state can sell this as long as they sell a non-managed care option. And with regard to the provider network, the only providers that are exempt from a managed care plan are the emergency room doctors, the basically emergency care. And then beyond that, people are stuck treating with the doctors the insurance companies want them to treat with. And there are other aspects of the managed care part of these reforms that are greatly concerning. And I think that because people are going to get a price break for it, they'll be convinced to go ahead to and select it. And when people are injured and they go pursue medical care, as you can see, there's so many questions for medical providers to ask now in order to understand coverage. But a big one is whether or not it's a managed care plan. Right now, I don't know of any managed care plan that's being sold at the moment, but I've heard that they're working on them and they're going to roll them out sooner than later. So I'm going to stop my screen share here so I can see what I'm doing. We're still within the first hour. We don't need to take a long break, but I thought maybe, you know, people want to just take a quick second before we throw a whole nother round of substance at you. I'm more than happy to take questions. I meant to summarize one thing. I think I skipped over in my last slide there. You know what? Here we go. I'm going to go back to my screen share here. 1 second. So these last 3 slides just summarize the insurance buying recommendations. It's you buy lifetime, unlimited, uncoordinated, non-managed care. And then regarding liability, you increase your liability insurance coverage. You buy an umbrella insurance policy, which covers what your auto policy doesn't cover. So if you have $1 million of auto liability insurance, your umbrella, if it's for 2 million, 3 million, 5 million, comes in and kicks in to cover the excess amount if somebody's catastrophically injured in an accident involving your vehicle. And then also uninsured, underinsured motorist coverage. This is a coverage you buy for yourself in the event that you're injured by somebody who doesn't have insurance or enough insurance. It's something that people should have always bought all along. There's no reason not to buy it under the reforms. There's probably more reasons to buy it. So make sure when you're talking to your agent about your coverages, you also talk about buying uninsured and underinsured coverage in the highest amount that you can. It's really not that expensive. So I'm going to stop the share there. And if anybody has any chats or questions, put them in the chat box, please. So hopefully that gives you an overview of how this crazy system is now working. I will say this, trying to predict how this is all going to pan out is, I think, impossible. I don't think it's not gonna be a system we like better, and we could like it a whole lot less, and we may even hate it, but exactly how it affects each and every one of us is something that I think we all have to take one step at a time. There's so many fights that are still going on. There's so many things that still have to be determined. And the other thing about auto insurance is that it usually doesn't stay the same. There's always some type of political pressure that can change things. And so I just hope that you all don't get too dejected thinking that, you know, the end is near. I don't know if it is or not. I just know that the only way you can operate and stay sane is by taking it one step at a time. And we'll just have to see how things pan out. I have a couple questions here. Is the uninsured, underinsured coverage different than an umbrella policy? Are these two separate policies that we should get? The answer to the second question is you should get both. And the answer to the first question is that they are definitely different. And I'm sorry to have glossed over it quickly and not make it more clear. So let me try to do it now. Liability insurance is insurance we buy in the event we make a mistake and hurt somebody. So on our auto policy, our liability insurance is what covers us. If we are hurt as a result of someone else's negligence and they don't have liability insurance, or they don't have enough liability insurance to cover our damages, we can make a claim through our own uninsured, underinsured motorist policy from our own insurance company if we have that. So if I'm insured by State Farm, which I'm not, but say I was, and I had uninsured, underinsured coverage, and I was hit by somebody who was uninsured, State Farm would stand in the shoes of the at-fault party and pay my damages to me. So it's a consumer protection you buy for yourself to protect yourself against drivers out there who could hurt you and who don't have enough insurance to cover your tort claim. An umbrella is coverage that you buy because you want to have more protection than you can buy through your liability auto policy. And most companies, a lot of companies cap their policies at 500. There's no company in Michigan that I know of that sells an auto liability policy with limits greater than $1 million. But now under the law, there's a real potential people could be sued for millions. So your $1 million liability policy might have sounded like a lot, but now under the law, if you have assets, it's possible you could be sued for millions of dollars of medical care, which is why the umbrella policy recommendation is being made. Can you list the types of insurance that should be purchased again? Yes. The other thing I should say, I can do it right now with the screen share. And then also our Smart Choices brochure is a primer on these options. And it gives recommendations that are just the same as I summarized here. But you guys can see my slides again?
Not yet.
Okay.
There we go.
So here are the 3 recommendations. Bottom line regarding no-fault PIP choice buying decisions. The safest option is for people to buy unlimited, uncoordinated, non-managed care, no-fault medical expense coverage. In other words, the way to summarize that is unlimited. You just say to your agent, I want unlimited no-fault. And for reasons I already stated, when you go unlimited, you might as well not be coordinated so you don't have to serve 2 different masters. If for some reason you feel the need to drop down and be capped on your no-fault policy, perhaps you should choose coordinated. But the bottom line here is unlimited, uncoordinated. That's on your no-fault portion. Liability, that's that coverage that covers you in the event you make a mistake. You buy as much as you possibly can. It really doesn't cost that much more to bring it up to the next level. It may cost more now under the reforms than it did before, but I don't think you're going to see a cost prohibitive jump between having $250,000 of liability coverage versus 500 or even up to $1 million. So buy as much liability as you can, and especially if you're a business owner, you better buy a lot more liability coverage, or make sure that you have as much as you can buy, because if one of your employees hurts somebody and you're a collectible business, you can be sued for a lot more money now. And then uninsured, underinsured coverage, it's the same concept about buying as much as you can, but that's to protect yourself in the event you're hit by a driver who doesn't have insurance or enough insurance. So those are the recommendations again. And somebody asked, if unlimited PIP is selected, why is uninsured, underinsured coverage required? It's not required. It's an option people have. The reason why you buy it, I tried to address this before, it's not any different. The recommendation we're making on uninsured, underinsured is not really changed by the reforms. We recommended it before because we've seen too many people who are injured and seriously injured as a result of the negligence of another person or even killed. And then they find out that that person doesn't have enough insurance or any insurance. And the family or the injured person wants compensation for their quality of life damages, their pain and suffering damages, or loss of life damages. And you find out that there's no coverage there. And that's when your decision to buy uninsured, underinsured coverage would trigger, and you would be able to at least recover something from your own insurance company, whether it's for your compensation as an injured person or your family's if you're killed. So it's, if you buy lifetime, you're not going to have to turn to that to cover your uncovered medical expenses, but it is still there to compensate you in the event that your life is ruined because of someone else's negligence. All right. Well, thanks for listening to me. I like to be around people in person when I present because it feels like I connect to them more. But hopefully that was easy enough to follow, and I'd be happy to take any questions via email. Steve Sinas at sinusdramus.com. I think my contact information is on materials you guys have. You should know how to get a hold of me. I'll still be around for Katie's presentation. How about this? It's 7:35. How about we start, or Katie will start promptly at 7:40. And unless Katie, you want to jump in now, I'll leave it up to you.
I'm fine either way, but I think I have enough time to get through what I need to get through if we start at 7:40, and I know I'm going to kind of totally switch gears. So why don't we all take a mental break for a few minutes if you need to use the restroom or get a glass of water or whatever. You'll have time to do that, and I will start right at 7:40.
Okay, there's one more question I see. Can you tell us more about the form requirement? We can send you a copy of the form to get you an idea about how complicated it is. If you follow those 3 recommendations, unlimited, no fault, as much liability as you can, as much uninsured as you can, you don't have to worry about the form. You just have to, like, skim through it and then just pick those options. But it just illustrates how complicated it's going to be for consumers. So we can definitely get that to people.
And if I can jump in here, I know when I talked to Alicia at your office about scheduling this presentation, she sent me, I think, 20 copies of the Making Decisions. And I've been sharing it with family members, and they're taking it with them when they go to meet with their insurance agent. Just
well, that's good.
So I think she would probably be willing to send it to anyone.
Yeah, and so real quick, we have the Smart Choices brochure that I think was made available to everybody, and if anyone wants it and didn't get it, we can make sure you get it. Just tell us. But that's out there. And then this thing about the form that I'm referring to is an actual DIFS, Department of Insurance Financial Services form that they put out for insurers to have to present to people in the insurance buying process as a way of making their selection of what insurance coverages they want. And so that's the form that is just very complicated and just gives you an idea about what consumers are going to be faced with.
And then I think there's a question on here about getting a copy of the presentation for reference.
Yes.
I think Steve might be able to answer this, but we are recording this so that we can post it on our Brain Injury Network website. Is that correct, Steve? Oh,
me?
Signed up. Oh, actually, Steve Perkis. Sorry.
Oh, okay. No, yeah.
Sorry, different Steve. Sorry. But if you're fine with that, I think that was the intention. Normally, we do put our presentations on the website for review later.
Yeah.
Okay.
All right. Well, we'll sign. It's 7:38. How about we go back on at 7:42?
Sounds good.
All right. Thanks.
Thank you. Thank you so much.
I'll be around, but I'm going to be behind the window here.
Okay. Just because it is 7:42, I know it looks like some people are still maybe filtering back in, and that's fine. For those of you who are on and listening, I just wanted to introduce myself again. I know a few of you, but see a lot of faces that I haven't met before. So my name is Katie Tucker, and I am an attorney at the Lansing office of Sinas Law Firm with Steve Sinas and several other attorneys. And I am a part of our firm's provider practice group. And in fact, that is the vast majority of my practice right now, is representing medical providers and pursuing payment under the no-fault system. I probably at this point have 40 or 5 cases in active, 40 or 45 cases in active litigation at any one time on behalf of providers for the purpose of pursuing payment under the no-fault system. And so these are all issues that I'm very intimately familiar with, and fortunately, or perhaps maybe more unfortunately, I have had the opportunity now to get very acquainted with the utilization review rules I'm going to be talking to all of you about tonight. And those really are going to change the game entirely for providers. And I know we have a meeting full of providers. It's really going to directly impact how you get paid, how you submit bills, how you pursue appeals. And obviously, everyone on this call is familiar generally with the No Fault Act, even though, as Steve did an excellent job explaining many of the changes that have been or will be soon implemented as a result of the 2019 reforms. Utilization review is not familiar to anyone because it's brand new. And so with that, I am going to share my screen with all of you. And I also have a PowerPoint presentation. And just sort of at the outset as well, I wanted to mention, if you have questions along the way, feel free to put them in the chat feature. I might not answer them as we go, but I certainly will hit all of them at the end, and the questions may come to you as we're kind of going along. I'm actually, so I don't distract myself by looking at all of your faces, I'm just going to take a look at my PowerPoint alone, and let's see if it's going to let me do it. Okay. So again, what we're here to talk about with me tonight are the proposed utilization review rules. And really importantly, everything I'm going to talk to you tonight about are just proposed. The rules have not been adopted or implemented yet. And so please take everything that I say with that very, very important caveat. There is still the potential for change, which I'll talk to you a little bit about in a few minutes. But we do have a full set of rules that have been released by DIFS, and that's really what I want to talk to you about tonight. So we're going to start with a forest view and then go into the trees, but essentially, what are the utilization review rules? What is that? It's a set of rules to govern the quote-unquote utilization review process, which is defined in the statute itself. I believe that your hosts have emailed or otherwise provided you with a copy of several materials that Steve and I put together. The materials that I provided include a copy of 2 sets of rules, and I'm going to talk to you about what each of those are, but also a copy of the section of the statute that gives DIFS authority to promulgate these rules. And I've copied a piece of the statute there, but essentially utilization review means the initial evaluation by an insurer or the association, meaning the MCCA, of the appropriateness in terms of both, 1, the level and the quality of the treatment, product, services, or accommodations provided under this chapter, but also of the cost, which we're going to talk more about. Why does DIFS have the authority to do this, or where do these come from? Again, from the statute, the legislature explicitly conferred on the Department of Insurance and Financial Services, DIFS for short, the authority to promulgate this set of rules. And the rules are supposed to do both of the following. First, to establish criteria or standards for utilization review. And second, to provide procedures related to that review, including, and you'll see them listed there, acquiring necessary records, bills, other information, allowing an insurer to request an explanation for, and requiring a provider to explain either the necessity or indication for the treatment rendered. And also the rules expressly under the statute are supposed to govern appealing determinations. We're going to talk a lot in detail about what that means exactly. But essentially, why do we have these rules? The legislature told DIFs to create them. Again, sort of a quick breakdown. Who promulgates these rules? DIFs. Who's assigned to adopt them? This actually is a result of the Administrative Procedure Act rulemaking process, but it's the Joint Committee on Administrative Rules. And who is that? It's 5 members of our state Senate and 5 members of the House of Representatives. And so there's a total of 10 legislators who are part of this committee, JCAR, and they are assigned to review the rules and ultimately decide whether to object to or adopt them. Under the rules, once implemented and adopted, who is charged with making decisions? The DIFS director, who's currently a lawyer by the name of Anita Fox, and who has a history of representing insurance companies and doing defense work, but she is our current DIFS director. Who must adhere to the rules? Insurers, any no-fault insurer in the state of Michigan, the MCCA, and providers. Now, this is an interesting point, and if you maybe saw a presentation I did several weeks ago that Steve Sinas was also a part of for CPAN, the rules have changed. The latest set of rules has changed to define a provider as a physician, hospital, clinic, or other person providing treatment, training, products, services, and accommodations to an injured person. Essentially, the rule has been changed to mirror the language of the statute. The rule previously, and we'll talk about this in a second, basically said that a provider is anyone who renders medical care. And so that left some ambiguity about who might fall under the purview and who might be subject to the rules. Would someone who provided case management services, for example, be subject, or someone who provided transportation services or guardianship services? With this new definition, it's pretty clear that a provider is basically everyone in the no-fault system. There's not a lot of ambiguity anymore about who is and who is not a provider. When do the rules take effect? Now, this is a really important question and sort of an interesting one. And the answer is that the rules are supposed to have taken effect as of July 1st, 2020. So 2 weeks ago, but for whatever reason, DIFS has sort of dragged its feet with this process, and we are still awaiting a couple of steps of the rules making process, and the rules are still not in final form. They have not been adopted. They are not implemented as of right now. Now, importantly, though, if you look at the language of the Rule 62(1)(c), which is only proposed at this point, and then you look at the language of the statute, it actually talks about the rules applying to treatment, training, products, services, and accommodations provided after July 1st, 2020. So this is kind of interesting. The rules still are not effective, and they haven't been adopted or implemented, but I think arguably all of you actually at this point, if you are rendering services or treatment, you are in fact subject to these rules. So even though we don't have the rules necessarily implemented, you are in a sense subject to them. I'm just trying to see if I can pull back so I can see the chat feature. Okay, give me 1 second here. Okay. So background and history. Essentially, how these rules came to be, at least the set that we have now, is that on December 16, 2019, DIFS released a first proposed set of rules. There were 25 in total. In February, they released a second set of rules, whittled down from 25 to 10. The first set of rules, I will say, was very, very problematic, and we had many, many concerns and objections. And so the second set of rules that was released in February did address many of the concerns that we had with that first initial set of rules. And we were glad to see that DIFS listened to many of the providers and to our firm and others who came forward and expressed concern. With the second set of rules, however, there were still concerns that we had. And in April, under the rules-making process, DIFS held a public hearing regarding that second set of rules, and then accepted public comments through April 17th. And then on June 30th, 2020, just 2 weeks ago, they issued a third set of rules and whittled the rules now down to 9 rules and a 5-page document, which again, all of you should hopefully have. But I'm holding it, and I'm also holding the rules that were released in March, because I'm going to talk a little bit more about those. Okay, let's see. Okay, let me see if I can change my screen really quickly. Okay. Okay, so going right into the rules themselves, and again, and I think I just saw a note from Sandy that she's going to make the new set of rules accessible on your website, which is great, because it is critically important that all providers who render services under the no-fault system review these rules and read them carefully and know them. So starting with part 1 of the rules, this is essentially a definitional section. And in this section, DIFS has defined medically accepted standards, which is going to come up later in the rules, as the most appropriate, just 2 things of note, the most appropriate practice guidelines for the treatment, training, products, services, accommodations provided to an injured person. These practice guidelines may include generally accepted practice guidelines, evidence-based practice guidelines, or any other practice guidelines developed by the federal government or national or professional medical societies, boards, and associations. And so essentially the purpose of that is, I'm just trying to figure out how I can still see. I wonder why it's not doing that. Okay, give me 1 second, because I'm gonna see, I can't see any of you now. And so I'm having a difficult time seeing if anyone has any questions or issues, but that's okay. We'll make it work. Give me 1 second, then we're gonna get back into it. Okay, let's try that one more time, because then I wanna still be able to see. It's not gonna let me do it. That's okay. We'll just keep going. So, like I say, part 1 is a definitional section, and 2 of the definitions that really stand out that you should be aware of. One is the medically accepted standards definition, which basically is the basis for an insurer making a determination about whether the treatment rendered by a provider is reasonably necessary, and also whether the cost is reasonable. And the second definition that we went over a few minutes ago that you should be aware of is this provider definition. And this definition is new to the latest set of rules that's been released by DIFS. And again, it's a broader, more expansive definition that makes pretty clear that if you are a family provider, if you are a family member providing attendant care, if you are an agency providing attendant care, if you are a guardian, a case manager, or anyone that we may more traditionally think of as providing medical care, you are going to be subject to these rules, and the specific definition is there, but anyone who's providing treatment, training, products, services, and accommodations. So anyone, again, operating under the no-fault system is going to be subject to these new rules. Moving on to part 2, and something I should have mentioned with the PowerPoint, you'll see that I have these little plus signs right here. Those are to indicate changes, amendments to the latest set of rules. So remember, we talked about a couple of minutes ago, there have been 3 iterations of this set of rules, whittled down from 25 to now 9. The latest set of rules has several changes which in the document that I've provided as part of the materials, the changes are actually highlighted to make it really evident and clear to you all. The changes are significant because they sort of give us a sense, I think, of DIF's intent with some of these rules, which I'm going to talk a little bit more about. But just as sort of a legend for the PowerPoint as you're kind of looking through it as we go through tonight, or if you take a look at this later to reference again, where I put a plus sign, that's a new amendment to this latest set of rules, and where it's red, it's supposed to indicate where it's a change that I'm concerned about, that I don't think actually really benefits our providers, and is something that that I think is actually not an improvement on the set of rules that was issued back in February. You'll also see sort of as a legend to this PowerPoint, a little caution sign. Again, just an indicator as we go through the PowerPoint, and if you reference this later down the road, reminder to you that this is something really to watch for, to be concerned about, and I'm going to talk to you right now about why. So Rule 62 is the scope and applicability section of the rules. It defines to whom, what, and when the rules apply. Again, we talked about rules apply to all insurers, the MCCA, and all providers. Rules apply to, again, the definition we just talked about: treatment, training, products, services, accommodations provided to an injured person for that person's care, recovery, or rehabilitation when, after July 1st, 2020. Rule 62(1)D is something that I want you to all pay attention to and that I'm concerned about. This rule expressly authorizes medical review organizations like ReviewWorks, MedAudit, Corbell. I know many of you are very familiar with these sorts of organizations to perform utilization review activities on behalf of insurers in the MCCA. The reason I flagged that and the reason that I'm concerned about that is severalfold, but essentially under the No Fault Act, the enabling statute, the statute that gives rise to this set of rules, the only two entities that are permitted to perform utilization review activities are insurers and the MCCA. Nothing in the text of the Act itself, which again is the statute that gives rise to these rules, allows for a medical review organization like ReviewWorks or MedAudit to conduct these sorts of activities. Now, we all know that insurers have for many years, decades, even contracted with those sorts of organizations to do their bill review and processing, but the legislature did not authorize that, and by incorporating that into the rules, we actually think that they are improperly exceeding the scope of the authority given to them, given to DIFs by the legislature, and objectionable for that reason. The other reason that I'm really concerned about this Rule 62(1)D is that it essentially replaces a rule that showed up in the previous set of rules that was issued back in February, so that second set. And that rule was Rule 68. And that rule similarly allowed review organizations to perform some of these activities on behalf of insurers in the MCCA. But that rule, the old rule, Rule 68, also provided some protection in a sense to providers. And what do I mean by that? Well, it allowed DIFs to gather and in fact required an insurer to submit several pieces of information about a medical review organization that it would contract. So for example, it was going to have to provide contact information for individuals at that organization, a detailed description of the organization's experience in the review of medical care, as well as a description of the medical review organization's procedures for utilization, a current list identifying all sort of conflicts of interest, if you will, all relationships that the review organization had with other players in the system, and any other information. So under the old rule, which has been scrapped, is no longer, old proposed rule, I should say, DIFS was going to have some oversight over this review organization handling of these utilization review activities. My big concern with the new rule is that it does not provide for any of that oversight. So it also does not define what constitutes a medical review organization. So, taken to perhaps its most extreme measure, I think this could be applied in such a way that, you can have basically anyone conducting these activities without any credentials or experience. And that's obviously a significant concern for obvious reasons. So that is a rule that we're hoping to challenge and that we think violates the statutory authority or exceeds the statutory authority, and that will be problematic. For some reason, this is not showing up as it should, but this is an important slide. I'm not sure why it's doing that. That's okay. Essentially, Rule 63 relates to requests for explanation, and I apologize that it's not, for whatever reason, formatting correctly, but in the next slide, I'll essentially get to what we need to know from this one. This rule identifies when and how requests by insurers can be made for explanation to a provider. And importantly, the requests must be in writing, and a provider that receives a request must respond within 60 days, or I'm sorry, within 30 days. That is a notable change from the previous set of rules. So an insurer at this point under the new set of rules has the right, has the ability to request a series of written pieces of information to include medical records, bills, other information that can assist it in assessing whether a service is either necessary or whether a charge is reasonable, and a provider must actually respond to that request within 30 days. The insurer also has some timelines that it has to comply with. One of those is it must submit the request for a written explanation within 30 days. And I apologize again, when I send a link to this PowerPoint so that all of you will have it, I'll make sure that the formatting issue here is corrected. But on the next slide, you'll see I have a little timeline that will be easier to follow. Another change from the previous set of rules is that the insurer now has 30 days to pay the provider what is called a reasonable and customary fee plus the actual cost of copying and mailing. So essentially, provider submits a bill, the insurer takes a look at the bill and says, hey, I need 10 other pieces of information or documentation. They send a request to the provider. The provider then has 30 days to respond to the request, and the insurer has 30 days to issue a payment for a, quote, reasonable and customary fee, whatever that means, plus actual cost of copying and mailing to the provider, knowing that it will take the provider and the provider's team time, effort, and money to actually put together the information requested, and so that's sort of the purpose there. But again, timeline for the provider has been shortened from the previous set of rules. It was 60 days under the rules that were released in February. It is now under the rules that have just been released and are the most likely to be adopted and implemented 30 days. So that's a pretty tight timeline. Again, just kind of looking at it, day 0, provider submits the bill to the insurer. Within 30 days of receipt of that bill, the insurer must submit a written request for explanation. And then within 30 days of the insurer request, a provider's response is due. And within 30 days of the insurer's request, the insurer must reimburse the provider this reasonable and customary fee. The old rule, instead of this language about reasonable and customary fee, talked about the provider's average hourly rate. And I think that would have been much more favorable language. And for whatever reason, DIF scrapped that and has replaced it with this sort of ambiguous reasonable and customary fee language, which I think is going to be problematic in application. But that is the current language that we're looking at. Okay, so moving on to part 3, and this is really the guts of, if you've been kind of tuning out, this is the part to tune back into. This is really the information that you're going to need to know moving forward. How providers are going to get paid moving forward, and importantly, how they are processing claims and appealing denials is going to completely change very soon. There are two rules, Rule 64 and 65, that are going to govern this. And Rule 64 deals with what are called determinations by an insurer or the association. So when do these determinations come about? After reviewing a provider's written explanation provided under Part 2 of those rules. So that rule that we just talked about, Rule 63, which says that a provider has to give the insurer or the association, MCCA, any of the information or documentation that it's asking for. Once an insurer gets that, it has the right under both the statute, and I'm going to talk about that in a second, but also now under these rules, to make a, quote, determination, to make the initial determination about either whether the provider has, and you can see this below, whether the provider has overutilized or otherwise rendered or ordered inappropriate treatment, training, products, services, or accommodations, or that the cost of that treatment was inappropriate. So either that the treatment was basically unnecessary or the cost of the treatment was inappropriate. And inappropriate within the confines of the statute and the fee schedule that's going to be implemented that Steve talked about briefly next July. Right now, we're still under this reasonable charge standard through June 30th of 2021, but for the next year, DIFs or insurers, the MCC and DIFs are going to be charged with determining what is a reasonable charge, which is going to be very interesting. So how does this determination come about? Well, the insurer actually does have to provide written notice of the determination. And that written notice must include 5 things. The first is the criteria or standards on which the insurer relied, with specific reference to the insurer's utilization review program. So this is good in the sense that, hey, it appears under the rules there have to be some criteria or standards, but a change that was made between the last set of rules and this most recent set, that is the current set, is addition of Rule 64 sub 2, which I have flagged there, as you can see. These criteria and standards can simply be the MCCA's determination. So even though it's great that we have this reference to criteria and standards, the rules have now been modified and amended to say that basically whatever MCCA decides can constitute criteria and standards. Bizarre and I think majorly problematic for a variety of reasons, but that is sort of the state of affairs with that first requirement for notice by the insurer. The second thing that a written notice of determination has to include is the amount of payment to the provider, including some explanation of the difference between that amount and the amount billed. And I know all of you are familiar with looking at explanation of benefit statements or explanation of reviews from all of these review organizations. And there will be codes that will identify why they're making a partial payment. Essentially, I'm imagining that this will be something similar. The third thing the written notice must include is a description of any additional records that are required. And again, I know all of you are familiar with this. This is something that we've seen in explanation of benefit statements and explanation of review statements in the past, but essentially, hey, if we need a prescription or an order for the service, the insurer is supposed to include that in its written notice. The fourth is a copy of the appeal form, which I'm going to talk about in just a minute. And the fifth is the date of the determination. And that is very important for triggering the deadlines and timelines for the appeals process that we're going to talk about in just a minute. So the time limit for the insurer is within 30 days receipt of the provider's written explanation, it must issue this written notice of determination. So essentially, the provider submits a bill, the insurer can request an explanation within 30 days. The provider has 30 days to respond to that request, and then within 30 days of that written explanation, the provider's response to the insurer's request, essentially 90 days from the date that the provider submitted the bill, the insurer has to issue this written notice of determination. This, you'll see, got the positive sign from me, because this is a changed. There was no time requirement in the previous set of rules, and that was a big concern because you know, our insurer is just going to drag their feet and let this go on for months and months, probably. And so that is actually one of the very few positive changes that's been made to this latest set of rules. What is the recourse for a provider who does not like this determination by an insurer or the MCCA? Well, it's to file, it appears at least to be to file an appeal with DIFS. And before we get there, just to kind of backtrack, where does authority, you might be wondering, again, how in the heck are insurers and the MCCA getting to make these like determinations? Well, it actually does come from the statute. The legislature did give them authority to make that determination. So that's not something that DIFS has come up with on its own. That does have a basis in the statute. Nonetheless, it's going to be interesting to see how it's implemented. So moving on to the appeals. We talked about insurer determinations. Okay, how does this appeal process work? Well, a provider may appeal that determination, that written notice, on a form prescribed by the department, on a form that DIFS comes up with, and I will tell you that there is no such form, at least that I'm aware of right now. So that must be something that they're working on. But the form, as you may remember from the last slide, has to be provided along with the written notice of determination to the provider. And if the provider is unhappy with that determination, which I imagine it will be in many cases, it has the ability to file an appeal with DIFS. And if it does so, it must do so within 90 days. So the language of this rule is that a provider may file an appeal. It's not required to, but if it chooses to file an appeal, it is required to do it within that strict 90-day period. So you're going to have a pretty short turnaround. Many of you, especially who have experience in litigating these types of claims or been involved in that process at all, are very familiar with the 1 year back rule and know, generally speaking, we have 1 year from the date of service, although now from the date that the insurer formally denies the claim, to actually file a lawsuit. Well, under this new appeals process with DIFS and this agency, you actually only have 90 days. So once you find out that the insurer is not going to pay your bill, you have 90 days to file your appeal and get your appeal form completed. And something else to note is that's actually, this is kind of interesting as I'm really looking at these rules, that really is the only opportunity that you have to submit something to DIFS is within that initial appeal form. Now DIFS can ask you, the director can come back to you and say, hey, I need more, but there's no other opportunity aside from that initial appeal form that's automatically granted for you to provide DIFS with any additional information. So it's absolutely critical moving forward, once this form gets released to the public domain and we all have a chance to look at it, that you review that really carefully, you think strategically about what documentation and information is going to be contained in that form, but that is going to be a critical part of this process now for providers. You're definitely going to want to spend time thinking about how to fill those out and the sorts of information and documentation you really need to provide. Okay, within 14 days of a provider filing an appeal, this is interesting too, the department, DIFS, has to notify the insurer or the MCCA and the injured person of the appeal. And they also, at that point, as I mentioned, have the opportunity to request additional information from the provider, but again, they don't have to. So if they don't, then you don't really get another bite at the apple to give them more information or documentation. Now, why I say it's interesting is that they're also going to notify the injured person. I actually think that this could be a good thing. We are always advocates of the patients and providers having a sort of a lax-up approach and working closely together to ensure that bills are being processed and paid and benefits that are owed are being remitted by the insurer. But it is something for providers to be aware of moving forward, because you may want to notify your patients on your own through a letter or some other communication if you are appealing an unpaid benefit. Otherwise, they're probably going to get something in the mail that they're not going to know anything about, that may be confusing or even alarming to them. And so as sort of a practice tip, I would recommend that you think about, depending on the particular services that you render and the relationship that you have with your patients, who might be in your organization the best person to notify the patient if an appeal is being filed, and how that notification may be submitted, whether that be in a letter or conversation, and if not with the patient, maybe with the patient's guardian. But otherwise, like I say, they're going to get something in the mail, and they're probably going to be confused or alarmed. So that's the notification piece. After a notification goes out, the insurer or the NCCA may, they're not required to, but may file a reply to the appeal. They have 21 days to do that after the date of that notice. The director then, based solely on the information and documentation submitted by the provider and a reply, if any, submitted by the insurer, makes a decision. And again, the director of DIFS currently is Anita Fox. And she, under these rules, is supposed to base her decision upon these written materials. And she is supposed to issue a decision within 28 days of the timeline expiring for the insurer to file a reply. And on the next slide, I'm going to give you a handy little timeline to kind of follow. She can, at her discretion, request an additional, or rather give notice that she needs an additional 28 days. So she's supposed to make a decision within 28 days, but that may be extended to as many as 56 days. If a provider is successful in its appeal, if DIFS finds in the provider's favor and finds that benefits that were not paid were in fact owed, and more than 30 days necessarily has elapsed between the time the provider billed and the time payment will be made, DIFS basically, under these rules, essentially has the ability now to find that the payment is overdue, that penalty interest is owed on the payments. And penalty interest is set forth under Section 3142 of the No Fault Act. And while it's a good thing in the sense that a provider can collect interest on bills that the DIFS director ultimately finds the insurer was responsible to pay and were untimely in doing so, we have some concerns, which I'm going to talk a little bit more about in a minute, about this language. Because we're concerned about some of the implications for an adverse finding, and actually now is probably a better time to talk about that. So under the current system, the way to get penalty interest and potentially attorney fees under Section 3148 of the No Fault Act is to have the trier of fact in the litigation setting, so either a judge or more commonly a jury, make a determination that benefits are overdue, that the insurer was supposed to pay within 30 days and they didn't, and therefore that the provider is entitled to 3142 penalty interest. The concern that I have is that by including this language in the rules, and essentially sort of making it part of the director's determination, if the decision by the director is not favorable to the provider, so if the director says, nope, the benefits were not owed, they're not overdue, no 3142 penalty interest, then if the provider goes to file a lawsuit in Ingham County Circuit Court or Delta County, or any other county in the state of Michigan, it's going to be that much more difficult to overcome this finding now on the record by the agency, by DIFS, that the benefits were not overdue. And it's going to be that much harder to get penalty interest through the civil litigation system and process. And so that's my concern with the reference to Section 3142 in the rules, and why I included a sign of caution here. It's good that you would be able to get penalty interest before DIFS if the director's finding is favorable, but again, if it's not favorable, it's going to be that much harder to get it in court. And, for the most part, we would rather see a jury make that decision than the DIFS director. The last section here is actually the most problematic. And I know this is pretty dense, and the slide is pretty dense as well. But if you can kind of hone in on this last subsection, this is really kind of the critical piece. And this is really our overarching concern with this entire set of rules and this appeals process. And we really have to get specific with the language. So this is the language. A decision issued by DIFS under these rules is subject to judicial review as provided in section 241-44 sub 1 of the Act. And the Act that this section is referring to is actually the insurance code. It's not the no-fault statute, it's actually a section of the insurance code. And let me skip to that and we'll circle back. Section 244 sub 1 of the insurance code governs judicial review, and it says this: a person aggrieved by a final order, decision, finding, ruling under this act may seek judicial review in the manner provided for in Chapter 6 of the Administrative Procedures Act. So what does this really mean? Well, it's leading us to another statute. And so we'll go there. Section 101 of the Administrative Procedures Act, which is referenced in that section of the insurance code, which is referenced in that rule that I just highlighted for all of you, says this: when a person has exhausted all administrative remedies available within an agency and is aggrieved by a final decision, the decision or order is subject to direct review by the courts as provided by law. Now, what is the potential problem with all of this? And I know this is some sort of gymnastics to follow, but the potential concern and problem that we see with the reference to this section of the APA and the other section of the insurance code is there is the reference to exhaustion of administrative remedies. We believe that rule subsection, I should say, subrule 65.7, again, this one right down here, could be interpreted to require a provider to go through this agency appeal process and to quote unquote exhaust its administrative remedies before it can ever file a civil lawsuit. Now, why is this a big problem? It's a big problem because last year when the legislature completely overhauled the no-fault system, one of the few positive changes, maybe one of the only positive changes, was the addition of language in section 3112 of the No-Fault Act, which gave providers a direct right of action to file a civil lawsuit. I'm sure some of you will remember the covenant craziness of a couple of years ago and the need to get an assignment in order to get into court. Essentially last year with the 2019 reforms to the Act, the legislature said providers now have a direct right of action, a direct ability to file a civil lawsuit in a Michigan trial court against an insurance company if they're not getting paid and they want to get paid. What this rule has the potential to do is to interfere with that right, and even to deprive or to significantly weaken the ability to exercise that right. And what do I mean by that? Well, in practical terms, if a provider, if this rule is properly interpreted or is interpreted to require a provider to go through this whole agency appeal process, which I'm going to show you in a second, takes about 6 months before they can ever file their civil lawsuit, not only are you going to be spending a lot of time, money, resources, effort trying to get paid and litigating your bills, but if you have an adverse decision from the DIFS director, from the agency, we believe at least you have the potential to have that much more difficult a time in civil litigation. If the DIFS director, if the agency finds against you, finds that your bills, your charges were unreasonable, or finds that the services you rendered to the patient were not necessary, it's going to be that much more difficult once you actually finally get to court, whether it be in front of a judge or a jury, to convince them that the DIFS director was wrong, because now we actually have a formal administrative finding that your bill was unreasonable or your service wasn't needed, it's going to be that much more difficult to overcome that. And so not only will it interfere with the right in the sense that right now, before these rules will take effect, you have the right as a provider to walk into any court and file a lawsuit against a no-fault insurer that's not paying your bills. There's some, of course, caveats to that, but for the most part, that's true. And if this rule is adopted and implemented as currently written, not only would you not be able to do that for several months until you go through this full agency appeal process, but when you finally do get to the courthouse, your ability to succeed on the merits of your claim is going to be hampered. So that's our really significant overarching concern. And if you kind of remember nothing else from this presentation, just remember that that is, while it remains sort of an open question, how that sub-rule is going to be interpreted and implemented. We are concerned because of the reference to that provision of the APA and the provision of the insurance code that it's going to be interpreted to require exhaustion of administrative remedies. Okay, so getting to this timeline and process for appeals to the department, this is kind of a summary slide. As you can see, I've given kind of example dates at the bottom, but from the date that an insurer or the MCCA makes a quote-unquote determination, let's say that was January 1st, 2021, provider has 90 days to appeal, April 1st, 2021. Within 14 days, DIFS has to notify the insurer and the patient of the appeal. And then within 21 days, or by about May 6th, if we're going from January 1st, 2021, the insurer or the NCCA may file a reply. Within 28 days of that reply, the DIFS director, again, Nita Fox, must issue a decision unless she provides written notice, and then she gets an additional 28 days. So at the, if every stage of this process, the 6-part process, takes the maximum length of time, you're looking at 6 months. And again, remember that this determination from the insurer and the MCCA doesn't come until about 90 days after the provider submits the bill. So the total process from the time the provider submits the bill until DIFS director actually has to issue a decision could be as much as 9 months. So this isn't a super fast process. The other thing that I should not neglect to mention, and I know we're nearing 8:30, or maybe we're right at 8:30, and I'll try to kind of wrap it up and answer any questions all of you have, is something that actually came up with in a phone call I had earlier today with one of my provider clients that I hadn't really fully appreciated until we talked about it, and that is this. You are basically going to now have to appeal every single bill that gets rejected, every single charge that gets rejected under the rules as they're currently drafted. You're going to have to appeal each and every one of those. Now, those of you who have been involved in litigation in the no-fault context know, generally speaking, we file a lawsuit when there have been several months of unpaid or underpaid claims, and you're not filing a lawsuit over every single rejection or underpayment along the way. The way these rules are drafted, and I think DIFS is going to think twice about them when they realize the logistical nightmare for them that's going to ensue. But the way the rules are drafted is that every single bill that is denied, essentially, you have to fill out this appeal form and DIFS director has to make a decision on. So to say that this is going to require a lot of time, effort, and energy on behalf of providers and potentially significantly increase the cost to providers of just getting paid is not an understatement. Or I'm sorry, is an understatement, is not an overstatement, and has potential to affect access to healthcare and ability really of providers to just get through all the bureaucracy and to make sure that they're getting paid at all. So it's a big concern and something just to be mindful of, that we're not talking here about appealing when you've had 3 or 4 months of non-payments or underpayments, and I think that's what many of you are sort of used to. And what I'm used to in representing providers is, you know, we have a big time frame and we're filing a lawsuit over that. It's now going to be essentially each and every non-payment that you are going to be forced to appeal. Okay, so moving on to part 4 of the rules, the Insurer Utilization Review Program. This doesn't necessarily directly concern all of you, but just so you are aware, there are requirements for this utilization review program. Insurers have to have a program in place within 60 days of the rules taking effect, and that program must provide for the following things: bill review, a way for the insurer to make determinations regarding the appropriateness of treatment, and I have that in red because the old set of rules referred to medical care and the new set of rules refers to this treatment, training, product, services, and accommodations, which comes directly from the language of the statute. And then the third thing that this utilization review program must do is allow the insurer to issue a determination, what we just spent a lot of time talking about under that Rule 64. Insurers are required to submit information about the program that they adopt to DIFS, which is good. And that document, that form, is accessible to the public through a FOIA request. So that's actually part of the statute. It's not referenced in the slide, but you'll see it in the proposed rules. Part 5, the final part, and I promise I'm wrapping up, the final part of these rules relates to an annual report, but most importantly for all of you, record retention. And that's the rule that I have on the screen. This is entirely new, and I have a red sign here because it's not necessarily a positive thing for all of you, because it's, again, more paperwork and bureaucracy, but you are now required to maintain copies of all requests, explanations, and determinations issued under these rules for at least 2 years. So I know and hope that many of you have cloud-based storage systems that will allow you to keep, maintain all of these sorts of records. But when you think about the fact that you're really going to have to appeal now every single non-payment, underpayment, you know, at least if you want to get paid, you're going to, you have to keep all of the paperwork that accompanies all of that for 2 years. It's, you know, just another sort of logistical mess that I think a lot of providers are going to have to contend with in the months and years ahead. So what's next? Well, we are actually at now step 6 of, or almost at step 6 of the rulemaking process under the APA. It's an 8-step process. And the next step is to submit these rules that were released on June 30th to the Joint Committee on Administrative Rules. They then have 21 days to review, and they can elect, they're not required to, but they have the ability to elect to hold a hearing. What happens next? They have a 21-day period to object to the rules. However, they can only object if one of several conditions are met. If the rule, and there, like I say, there are several, but essentially if the rules are in excess of the scope of the enabling statute, which we believe at least a few of them are, or if the rules are arbitrary and capricious, and again, there are many other legal standards, but they can't just object because they don't like the rules. They have to actually fall under one of these specific conditions. And the committee can only object to the rules with approval of a concurrent majority of its members. And again, it's a 10-member committee. If no notice of objection is adopted, if Joint Committee of Administrative Rules does not take umbrage with any of the rules and does not file a formal objection, the rules may then be filed with the Office of the Great Seal, and they will become effective 7 days after filing. Now, what is the word on the street as to when I think these rules may actually be adopted and become effective unless they go through some change? I've heard sometime around September. I think that's when the committee is planning to meet again, and that's sort of the time frame that I've heard. So I imagine that we will have something at least by fall, but maybe as early as September. And again, if we go back to one of those earlier slides, technically the way the rules are drafted and the way the statute is drafted, you are essentially required to comply with the rules insofar as you are providing services, and we are currently, it is currently, I should say, July 16th after July 1st, 2020. And so there's at least an argument that you're required to adhere to these, these rules as of right now with regard to the services you're providing. So what are the takeaways? Read and review these rules really carefully. No question, you will be subject to and governed by them very soon. This is a great time, especially if you are involved in the billing and collection process of your organization, to talk to your staff, colleagues about how you are going to change your practice. I can't imagine a situation where a provider is not going to have to make some changes about how they're doing things. I know many of you are used to, or your billing staff is used to filing appeals with insurers and sending collection letters and notices, and you may have sort of a procedure or process in place for that. I think in a sense, really, that's going to have to get scrapped, and you're going to, instead of appealing this again and again with the insurer, you're really going to need to file your appeal with diffs on this form, which is yet to be released. So I have no idea what it will or will not require, but as soon as I do, I would be happy to provide that to Sandy or anyone else to share with all of you. So the really important thing is to stay tuned. Lots to come here, and I don't mean to be the bearer of bad news, but the world of provider claims processing and appeals is going to completely change very, very soon. And unfortunately, I don't think it will be for the better. But hopefully, you at least have some time to kind of get your bearings, and hopefully this information has been helpful. So I'm going to kind of take a look down and see if there are any questions specifically for me. Okay, so I see a question about, is there a way for them to get around the changes as to who can provide IME? So in Rule 62, okay. And I'm thinking that the reference to Rule 62 is because of, and Mark, feel free to weigh in here if I'm not getting this correctly, or I'm sorry, Sandy asked that question. If I'm not addressing directly what you wanted to talk about, but I think where you may be going with that is the fact that medical review organizations can be involved in this whole process and are in fact expressly authorized. So IMEs are still governed totally by the No Fault Act. So all of the rules set forth under the statute apply to limit who can conduct IMEs, how they can be conducted, etc. And we believe, because the rules do not address IMEs specifically, and on that note, it's important to point out that the old set of rules that was issued back in February did address IMEs. And we complained about it, and we objected to it, and they removed that reference. So we believe, because they've removed that, that it's pretty clear that courts get to decide how IMEs are conducted and make any determinations about the propriety of an IME in any given case. Saying that, however, I think realistically what is very much still going to happen is that as part of this whole utilization review process, and as part of these activities, medical review organizations, insurers are going to send claimants to get IMEs, early on in the process, and that information potentially will get submitted to the DIFS director and be considered among the body of information that's considered when she makes her determination. I don't think there's anything that stops them from doing IMEs early in the process so that they can submit that to DIFS directors. But in terms of your specific question, will it change who can provide them? No, nothing in the rules addresses that. So that's still, the statute governs that, which is good. From Mark, with limited benefit funds, who determines what services have priority? And I think what you're asking there is really if a consumer has, and Steve talked extensively about this, but chooses something less than what we're recommending, the unlimited, uncoordinated lifetime medical coverage, if they have some sort of a cap that applies to the medical coverage that they have, I think the question is, you know, who's going to make the determination as to what medical provider is going to get paid out of that cap, and who's going to be left holding the bag and not get payment? Well, the answer to that really is probably going to be, if we're interpreting that sub-rule 7 correctly, it's probably going to be the DIF's director in a sense, and it's going to be, and by that I don't mean to suggest that she's going to specifically answer that question, and I'm happy, Steve, if you have other thoughts or want to weigh in on this one too, but I think the way it's going to work out in practical terms is insurers who are not getting paid for whatever reason, and that may include the fact that the cap has been reached, are going to have to file an appeal with the DIF's director, and then she is going to, through this whole appeals process that we went through at length, she's going to make a determination about who gets paid and what, essentially. Now, it's not, that question is a really important one, it's a really interesting one, it's a good one. It's not specifically addressed in the rules, and I'm sure it will become a problem, and then perhaps the rules will be amended to give some more specific guidance on that. But that's really my best answer right now, is I think in practical terms, in some sense, it's going to be dependent upon, and this is why it's so critical, if you are a provider and you want to get paid and you're not getting paid, that you do go through this appeals process, and you do it timely. Being timely here is going to be everything. I know many of you who are familiar with the one-year back rule know how strictly that has been applied historically by our courts. And I think the same thing is going to be true of these rules and the timeline set forth under the rules. And, you know, as I mentioned a few minutes ago, it's about a 9-month process, start to finish, from bill to provider, or I'm sorry, to DIF's director determination. But the appeals process alone is six months. And so it's lengthy in the sense that it would be nice if, you know, you could get your bill paid sooner than 6 months. But it's tight in the sense that you used to have a year to make a decision about whether you're going to challenge this and essentially litigate the non-payment. And now you're going to have to make that decision in 90 days. You're going to have to, so they've, you know, essentially cut by your time frame by 75%. So it's going to be a tight turnaround. You're going to have to be prepared to make those decisions. Does anyone else have questions? Steve?
I just was going to add a couple things about this question. I saw something the other day from the assigned claims plan that they're basically going to follow with regard to their cap. Now, keep in mind, there's a whole bunch of people that are now going to go into the assigned claims plan, as I summarized before, and they're all going to be capped at 250. And they had some memo or directive that went out within the plan saying that they're going to follow first in, first out type of approach, where they're going to pay the bills they get first, and you know, whatever they get in, they're going to pay. And when they pay it up to their cap, they're going to tell the next bill that the cap's been breached or exceeded. So to tie it into Katie's comments, even though we're all taking all this bad news and thinking that it's just going to be bad anyway, that might be true, but you're going to lessen the damage by being diligent and getting your bills submitted as soon as possible. My comments in terms of that directive have to do with the ACP. Just to also add to Katie's comments, the rules don't apply. And I actually think that what's going to happen is that the insurers are probably going to follow the same method. If somebody's seriously injured and they're, you know, they get the ambulance bill, they get the hospital bill, they get the professional services bill related to the hospital hospitalization, and then maybe the first few rounds about patient care, whatever bills they get in, they're going to pay. And once they've exceeded the cap, they're just going to start rejecting bills.
Mm-hmm. Yeah, I think you're exactly right. And that would make sense too in terms of this DIF's process, because they're essentially having to justify to the DIF's director why they did or did not pay a certain bill, and a first in sort of approach, you know, I could see being considered reasonable under the circumstances. So diligence is the name of the game, and you know, and I know all of you on this call, just by virtue of the fact that you're spending your Thursday night in July and it's beautiful and you could be doing something probably more fun with us means that you are diligent and you're going to be far ahead of the game. Yes, you definitely have to be proactive here. You had to be before, but it's a new level coming up pretty soon here. So does anyone else have any questions? I know I talked fast and I went through a lot, but if you have any questions, feel free to add them into the chat. I know we're about 15 minutes over, sorry. Or feel free to email me directly. My email address is Katie Tucker, and it's Katie with the K, even though it's Catherine with the C, just to confuse you, but Katie with the K, Tucker at sinusdrainage.com. And I will get back to you as soon as I can. I'm also happy once the rules get implemented, if there have been changes made, I'm happy to come back and talk to you all again, or to send you updated materials and information, and to hopefully be a resource for all of you. So I appreciate your time very much, and it was a pleasure to meet all of you virtually, and I hope that we can meet in person at some point in the coming months, and I wish you all well, and hope you enjoy the rest of your night.
And please do what you can to spread the word to people you know about the insurance buying process. I think this is more of a grassroots campaign where, obviously we can't go into every single house and connect everybody in Michigan, but if you give those recommendations to 10 people, that's 10 people that are going to have better coverage. So
I know we
thank you very much.
Thank you to both of you for taking your time tonight. But Steve, I have one more question. Do you have any other comments about next week? I know Brain Injury Association sent out an email in the last couple of days talking about the court hearing next week, and that they were going to send out links for us to observe on Zoom. Is that?
Yep. Yes, I believe that's going to be available. This has been a ever-changing process with when this hearing is going to take place and how they're going to go about it. But my understanding is that there will be an ability for the public to tune in, and whether it's going to be that the public can tune into Zoom, or if they're just going to have to watch a live stream through YouTube. Either way, the courts have an obligation. They've had an obligation, even in a non-notable case, to make a hearing public. So they already are equipped to do this, and it's just a question of how they're going to handle this particular hearing. But there'll be more information in the days to come here about how to do that.
Super.
And I just say to people, this case is a case involving individuals and providers, and it's geared towards getting rulings on a number of different issues. I don't have the time. We've already gone over here to explain it all, but it's just at the trial court level. So, whatever ruling comes out of the trial court, and I don't even know if she's going to give it on the 22nd, or if it's just going to be an argument, they take it under advisement. It could go that way. But it's a ruling that it's either going to be, in our favor or in their favor. But the game's not done there. You got appellate land to go through for sure. So this is just the beginning. But what happens in the trial court shapes how the case is then litigated on appeal. So we certainly hope for victory. It'll be a big event, but it's not the end all be all of these issues by any means.
Thank you so much. And thank you to everybody for joining us tonight. We will try to put the information on the website so that the members can access it, and we'll keep spreading the word.
Thank you. Have a good night.
Good night. Good night, everybody.